106. How much notice am I obligated to give employees who are about to be laid off under the WARN Act?
The Federal Worker Adjustment and Retraining Notification, WARN, Act may govern the notification requirements and obligations of a layoff when you plan to close an entire plant or to lay off workers en masse. The WARN Act is extremely technical and should be reviewed with legal counsel before any action is taken. Following are some its key terms. Jurisdiction: WARN applies to businesses that employ a. 100 or more employees, excluding part-time workers, or b. 100 or more employees who in the aggregate work at least 4,000 hours per week, excluding overtime hours. Plant closing: the permanent or temporary shutdown of a single employment site or one or more facilities, operating units within a single site, if the shutdown results in an employment loss during any 30-day period for 50 or more employees, excluding part-time workers. Mass layoff: a reduction in force resulting in an employment loss at a single work site during a 30-day period for the lesser of a. at least 33% of the employees and at least 50 employees, excluding part-time workers, or b. at least 500 employees, again excluding part-time workers. Employment loss: this is a termination other than a termination for cause, resignation, or retirement, b. a layoff exceeding 6 months, or c. reduction in work hours of more than 50% during each month of any 6-month period. Notices: the employer must give 60 days advance written notice of a plant closing or mass layoff to a. each affected employee or, in the case of unionized employees, to their union representatives, b. to the state dislocated worker unit, and c. to the chief elected official of the local government. Tell me more. Determining whether your company should be governed by the WARN Act can be a complex issue. In the event of a mass layoff, if 500 full-time employees are to be laid off at a single site, then WARN applies. In the same situation, if 33% of your full-time workforce, and at least 50 employees, are going to be laid off at a single site, then WARN applies. But what if the layoffs are planned over 6 months, rather than 30 days? What if employees at different work sites or employees of separate and identifiable business units within the same physical site are being laid off? You can see where the WARN application gets tricky. More important, can your company structure the layoffs to avoid meeting the WARN thresholds? For example, if you lay off fewer than 50 employees now and wait 30 days before laying off additional workers, can you avoid WARN's provisions? This is a question for legal counsel and goes well beyond the scope of this book. Finally, understand what WARN isn't meant to be. Layoffs that affect fewer than 50 workers at any given time are not governed by the Act. Plant closings or mass layoffs caused by events that are not reasonably foreseeable, for example, natural disasters or union strikes and lockouts, may be implemented on less than 60 days advance written notice. The 60-day rule also does not have to be strictly followed if the company is, at the time notice would be required, actively seeking capital to continue its business operations and in good faith believes that giving notice will hasten the acquisition of capital. In addition, the law wasn't intended to protect workers who lose their jobs less than 60 days after the sale of the business. It is, instead, intended to protect workers only from closings or layoffs prior to a sale. Penalties for failing to provide appropriate notice to displaced workers may include back pay for up to 60 days, the costs of employees' benefits for that period, and fines not to exceed $500 for each day of the violation. However, the company's liability for back pay and lost benefits is reduced by any wages paid to employees and by the continuation of benefits for any period of the violation. If the WARN Act does not apply to the layoff you are planning to conduct, then you have no legal obligation to provide employees with advanced notice. Instead, you may lay off employees immediately, and the timing or type of notice and separation payments will depend on company policy and other contractual obligations.